Tyler Barrett. I am the founder and principal attorney at Barrett Legacy Estate Solutions. We are a boutique estate planning firm located in Norman, Oklahoma. And we strive to help clients protect their legacies, safeguard their family's future, and a big part of that is ensuring that the next generation, that the successor trustee is equipped to do the job that they've been appointed to do. So I'm going to provide a general overview of trusts and successor trustee roles, responsibilities, and options. So our objective here today, so what is an estate? I think it's important before we delve into successor trustee, in particular, to talk about what an estate is. There's sometimes misconceptions about that. And so try to clear up some of that. Then what are your responsibilities if you are named as a successor trustee by a friend or loved one? What issues do you need to be concerned about? So a lot, I would say, but we'll try to hone in on the ones that are most pertinent and that have the biggest potential to cause discord and throw things off track in terms of the intent of the creator of the trust. And then what are your options? So as I'll talk about in more detail here in a little bit, there is no set playbook for how to administer a trust. So it's a bit unlike probate in that way. And so there's some different options about how one might approach things. And so I'll cover that and explain the best practices. So we'll kind of jump right in here. Spots on the x-ray here. So this is intended to really just show all of the different things that can happen with an estate. And so that is, from anything from joint tenancy to lack of succession planning, lack of business exit planning, second marriages, non-citizen spouses. Maybe there's a child with a substance abuse problem or who's a big spender. So there's a number of different things that we are trying to look at when it comes to estate planning. And so, it differs from client to client. And it's really, our focus is learning what the client is truly concerned about, what their wishes are, what their family situation might be. And so people think of estate planning as documents, and they certainly are documents, but that counseling, that kind of understanding what legacy someone wants to leave is important, and it's different for everyone. So what are some of the priorities when we're doing estate planning? So I've got here, a pyramid that kind of shows some of the different priorities that we might want to be concerned about. So, of course, ourselves. That's often overlooked in estate planning. So we're so, so concentrating on what's going to happen when we pass away that sometimes we forget how to take care of ourselves while we're still here. Particularly if we have a health issue, we lose capacity, maybe due to dementia, stroke, something of that nature. And so we need to think about that as well. Our family, of course. So I think I could safely speak for everyone. No one wants to be a burden to their family. And beyond that, everybody wants to, to make sure that if something happens to them, that their family's taken care of, that they're going to be all right. And so that is a major priority in estate planning. Wealth. So, if you have an estate plan and you've created wealth, you want to pass that along to the parties that you want to benefit from it. And so we want to make sure that we're doing that in an efficient way, that we're doing that in the least costly way possible. And, something I can speak on from personal experience is not having any discord in the family, not having the family go through litigation, which really can destroy wealth and end up in the pockets of attorneys in the court system. And then expand wealth, right? So there's an opportunity really, depending on how an estate plan is structured, to not only transfer the wealth that currently exists, but to expand it over time. And so for the family to grow wealthier over time. And so you may hear people say, or maybe you yourself have remarked, that you want to create generational wealth. And that's what people are typically referring to, is we want to not only pass this wealth down, but expand it over time. And then save on taxes. So, if you've been following the news, there is some news on that. The tax bill working its way through Congress, or not working its way through Congress, I guess, depending on what day it is. But estate taxes, inheritance taxes, that can be a situation where, rather than money ending up with your loved ones or charitable causes that are near and dear to your heart, it ends up in Uncle Sam's coffers. And so some people are okay with that. A lot of people aren't. And so there's things that we can do with trust-based planning to mitigate taxes. So what is all of this, and what is an estate? So an estate, quite simply, is everything that a person owns. So that can be anything from your car to jewelry, artwork, cash in the bank, so savings accounts, checking accounts, CDs, your retirement accounts, so those 401ks and IRAs, your house and other real estate. And then, one thing that people kind of forget when they're thinking about estate planning is life insurance. So, our estate is not only what we can tangibly see and use right now while we're alive, but is also benefits or money that might be there for our family when we pass away. And so, that life insurance, if it's a term life insurance policy that doesn't have a cash value, that's not something that you can go to the store and buy a service or a product with. But it is money that is going to be there for the family when you're gone. And so we need to plan for it. And I think that's important with younger clients. So here at our firm, Barrett Legacy Estate Solutions, we serve clients, across the age spectrum. But I would say, compared to other estate planning firms, we do have somewhat of a younger client base. And so sometimes when I'm meeting with people in their 20s, their 30s, they'll say, Tyler, I don't have an estate. I don't have anything. We don't own a house yet. But maybe they've got that life insurance policy. So it's really anything that you own or that might become money after your death. And so when we're thinking about our estates, what do we want to do? So what type of instructions would we leave if we were going away forever? And so I'll pose frequently the question to clients this way. So I'll say, if you passed away today, what would you want to have happen to your property and your accounts? And so then they'll answer that question. I'll say, okay, if you passed away today, what do you think would happen to your property and to your accounts? And, very often there's a mismatch between those two things. And so that's the trick of estate planning, is let's figure out how to leave instructions that are going to ensure that what the client wants to have happen, what you want to have happen with your property and with your money, is actually, in fact, what happens. And, I see so many estate plans out there that are just, kind of what I call I love you plan. We'll just, here's all the money outright, do whatever you want with it. And that introduces all kinds of variables into the mix. And that could be okay for some people, but for a lot of people, we need to leave more detailed instructions. And so, estate planning historical definition here I've got on the slide. So I want to control my property while I'm alive and well, and I want to plan for myself and my loved ones if I become disabled, and give what I want to whom I want, when I want, the way I want, and all at the lowest possible cost. So, it's kind of like the best of all worlds, and one of the cool things that I really, really enjoy about my job is it's kind of like putting a puzzle together. We have all these different priorities. You can see here on the screen, all these different possibilities, like I discussed a couple slides back, and all these different family situations. But it's really neat to be able to take all of that, to work with the client, to get to know them, get to know their story, and the legacy they want to leave, and then, have that puzzle come together and just see the relief that the clients have, and kind of that weight that's been lifted off their shoulders, and some of the just really cool things we're able to do. So, here is kind of typical estate planning goals. These are, I think, things that everybody has as a goal. So, avoid guardianship on disability. So, a living probate, as we also call it. So, if an individual does not have any estate planning documents, so they don't have a will, they don't have a trust, they don't have powers of attorney, then they could end up in a guardianship if they ever reach a point where they can no longer manage their money and their property on their own. And so that's costly. It's time consuming. Frankly, they mentioned publicity, but frankly, I would say it's a little bit demeaning, right? So somebody who is going through something traumatic, something unpleasant like Alzheimer's or another cognitive disability, having to be hauled before a judge and, ask questions, possibly subjected to doctor's examinations upon doctor's examinations. It's just not something anybody wants to do. So we want to try to use estate planning to avoid that living probate or guardianship. Then we have death probate. So probate after death. So in my world, probate is kind of a four-letter word, right? It's something that we want to avoid at all costs. And, why do I say that? Well, some states, probate is not really that big of a deal. So, I think Colorado being one of them, if there's anyone that has family or friends up there, maybe say, oh, well, my neighbor or my cousin or whatever, they went through probate and it wasn't bad at all. And that very well could be the case because probate laws are different from state to state. But here in Oklahoma, probate is kind of a big deal. So it's costly. It could be easily kind of on the low end, $4,000 to $5,000. If you get into a situation in probate where there are creditors, where there's any sort of tax issues or disputes between the family, that can increase the cost very quickly to $10,000 or more. Timing. So probate, can't be done quickly, and we here, when we're handling probate cases for clients, we try to push it through the court system as quickly as possible, right? But we're dependent on the judge, the probate judge. And, really before we can do anything, we have to get the judge to sign off on it. And judges, as you probably know, have hundreds, if not thousands of cases. And so it's not as though we can just, I can walk down to the courthouse and say, hey, judge, I need this probate matter heard tomorrow because, the family wants to get on with it. So, can take quite a long time. And that delays, the parent or, the deceased wishes from going into effect, right? So they may say, hey, I want this money to be spent on family vacations or my grandchildren's college education. But the money is tied up in the court system and we cannot make that happen for a period of time. And then finally, as with guardianship or living probate, probate after death is public proceeding. So here in Oklahoma, there's a website called oscn.net. Some on this webinar may be familiar with it. That's our Oklahoma Supreme Court Network website. On that, you could go and look up the details of any probate in Oklahoma. I can see who the people were, how they passed away, when they passed away, who they're leaving their estate to, maybe who they're not, how much money they had. So it's all very public, and I was always taught by my family, by my parents that, you don't broadcast out there to the world, how much money you have or how you're spending it necessarily. It's kind of a private thing. And with probate, sadly, there's no way around it being public. And then we want to reduce or eliminate estate taxes. So, this isn't as big of a concern as it maybe was, say, 20 years ago, but it's definitely something that should still be on our radar when we're conducting estate planning. And I'll talk more about that in a bit. So what else with planning? So healthcare. So I was talking about how the focus of estate planning is most of the time on what happens after one passes away, but we want to make sure that you're taken care of while you're alive, right? And so, we're all, right now, aware enough, of sound mind, able to make healthcare decisions, for ourselves. So if I am walking down the sidewalk, it looks like it's about to rain here again, as if we haven't had enough of that already in the spring and summer. But say I slip and I break my leg. Well, I can, tell my doctor, yeah, I would like to have surgery, or no, I don't, or just put me in a cast. I have options. I can make decisions. But let's say that happens to me and I also have Alzheimer's disease. I'm not of a state or in a state where I'm able to communicate and legally make those decisions on my own. And so I need a document, or I should have a document, we all should, where we appoint someone that we trust, who shares our values and our approach to healthcare, who can make those decisions for us, right? And so there's a statutory form that's kind of what I call a bare bones, right? A type of power of attorney for healthcare matters. And then there's also a general durable power of attorney for healthcare, which would be more all-encompassing. And typically that's the one that we're going to want, because we can't anticipate every kind of situation that might arise. We don't want to limit the authority necessarily of the person that we're appointing, provided that we trust them and all of that good stuff. And so who should have the authority to act? That's again, someone that you trust, someone that has your best interest at heart, and aligns with your views on the world. I mean, so we all have kind of different things that we believe in terms of healthcare and how that should play out. And so it's critical that you choose an agent, or healthcare proxy, as we call it, who is on the same page as you. And then, is it current? So this is something in our practice we've run into a lot, especially over the past few years, is so we have to jump through all kinds of hoops to get that document enforced. Meantime, there may be serious health decisions that need to be made on the client's behalf or on your behalf. And so it's important to make it updated and current. You also maybe, unlike with wills or trusts, it is useful to have a healthcare proxy who is, in the same geographic location as you, so they can do things like take you to doctor's appointments and the like. And so maybe you have a healthcare power of attorney that you did many years back, and it lists a family member who, no longer lives near you. And so it would be prudent to kind of consider updating that and appointing somebody different. And then legal directives, or what we call in Oklahoma, advanced directive for healthcare. Some states call it living will, but we refer to it as advanced directive for healthcare. So that document is specifically for end-of-life decision-making. And so some people may recall the Terry Schiavo case. She was a young woman in Florida who suffered a tragic stroke and rendered her completely incapacitated, in a coma. And the doctors got to the point where they determined that she was never going to come out of that coma. And so I may be mixing these up, but I think her spouse, her husband, said that she would want to be taken off life support. Her parents, on the other hand, said no, she would want to keep receiving life support for as long as possible. But there was no document that clarified Terry's decision either way, right? So the doctors didn't know what to do. Ended up actually before the Supreme Court of the United States, believe it or not. And so that advanced directive for healthcare is a critical document to make sure that you're treated how you want to be treated at the end of your life. And so that's what you can do, is set forth your wishes ahead of time. So kind of got here, I'll just let you, read that. So what provisions are in a healthcare power of attorney? So the authority to discharge or hire medical providers, patient advocate, hire a care manager. That's someone who can help coordinate long-term care in a nursing home or assisted living facility setting. And then pain relief, consent to pain relieving drugs, fill prescriptions, all of those kinds of things. So again, very, very important. So what about a general durable power of attorney? So this is for financial matters. So we have kind of here runs the gamut as someone, if you're incapacitated to make real estate transaction decisions on your behalf, buy or sell property, deal with your bank accounts, stocks and bonds, access safe deposit box, receive Social Security. So if you're incapacitated, you need to have what we call a representative payee, someone to get those Social Security benefits and apply them for your benefit. File tax returns and kind of so on and so forth. But you see, the idea is that someone who can step into your shoes if you're not able to make decisions for yourself. So, and it should have estate and long-term care planning provisions. So giving flexibility for the agent under the healthcare or the general durable financial power of attorney to arrange for estate and long-term care planning, enter into caregiver agreements. Some of those things that happen there when a person becomes incapacitated. So estate taxes. So what are those estate taxes? It's a better tax on everything, right? So at Oklahoma level, we abolished our estate tax or inheritance tax at the state level back in 2010. So it's not something we have to worry about now. But the federal government still assesses an estate tax. So it is right now a 40% tax on everything that a person has. So all of their estate, as we discussed earlier. So home, personal property, bank accounts, investments, IRAs, life insurance. Right now, so if someone dies in 2025, that exemption is $13.99 million per person. And for married couples, we can double that, and that makes it near $28 million. And so the vast majority of the people and the families that I work with, this isn't something that we have to worry about how that works. And so it's kind of on the back burner, but some of you maybe been following the news, the so-called big beautiful bill, right? So it would extend the current estate tax exemption levels for the long term, which are set to expire as of December 31st, 2025. So if that bill does not pass or it is changed, there's a possibility that a lot of folks may have to reassess whether they need to do estate planning specifically to avoid the federal estate tax. But for right now, not something to be too worried about. So sobering statistics. I feel like I tell my wife Maddie a lot that I feel like the Grim Reaper sometimes, because I'm really delivering bad news, or I'm talking to people about things that really nobody wants to think about. But to do an estate plan properly, we have to have people be aware of these things. And we all, when it comes to our family, right, we all kind of have blinders on, those rose-colored glasses. So it's my job. I feel like I'm not doing a service for my clients unless I am having them, think about these things that nobody wants to consider. And see if it's relevant to the plan. Do we need to plan for it? And so here I've got, our children have a 1 in 2 chance of either getting divorced or going bankrupt. Again, really terribly sad to see, but that's just the reality of modern life. On average, it takes someone 19 months to go through their inheritance. So one of the sayings that I think really hits home for people is shirt sleeves to shirt sleeves in 3 generations. So the first generation earns the wealth, the second generation preserves it, and the third generation burns through it. And so there's some controls with estate planning, trusts especially, that we can put on inheritances to make it last long, to make sure it's used in a way that the client that you would want, that reflects the client's values and family traditions and all of those things. And so the remarriage of a surviving spouse may disinherit children. So we've probably all seen this one, unfortunately, but somebody who's been married for a long period of time, maybe their spouse passes away, and then somebody else enters the picture, and maybe they have good intentions, maybe they don't, but that all that wealth and that estate that the person has spent years building up with their first spouse could end up not with their kids, but with actually their new spouse. So kind of an extreme example, but I don't know. For those of you who are sports fans, have seen the whole saga with Bill Belichick, right? And so the former Hall of Fame coach of the New England Patriots, and so he has linked up with a much younger woman, and apparently now they are going to be married. And so there's a lot of concerns that the money that he has accumulated and the estate he's accumulated may not end up with his kids, may end up with her. So again, extreme example, but just all things to think about and that we can plan for in an estate. So there's different types of estate plans. There's a will-based estate plan, which is really the basic foundational document in estate planning. And so that's your written instructions about how you want your stuff to be dispersed whenever you pass away. And so I tell people this document, it's simple, it's straightforward, but it's limited in what it can do. So for one thing, wills must go through probate, so they don't mean anything until a judge says that they do. Number two, some of that ability to control how the inheritance is used or the purposes which it's applied toward, we don't have as much of an ability to do that with wills as we do with trust, which I'm going to talk about. And then again, it's just it's just really the basic document. I mean, everyone should have one, but and there's some people where that's all they need. I tell clients sometimes, my grandmother on my dad's side of the family, she just had a pension, her house, and a bank account. My dad was an only child. His dad passed away when he was in college. My grandmother never remarried. And so, there wasn't really a need for her to really be super extensive with her estate planning and go the trust route. But for a lot of people, living trusts are something to consider. So what is a trust? So there's different roles. So the focus of this webinar this evening here is successor trustee training, but there are different roles. So there's the trust maker. You may have also heard this referred to as a grantor or a settlor. And so that is the person who is establishing the trust. There's the trustee. So they are the manager of the trust, and how they manage that trust is very crucial. And a lot can go wrong along the way. The trustee or manager can subject themselves to a lot of liability, and we want to avoid that. And then there's the beneficiary. So the beneficiaries are the people whom are receiving the property or the money of the trust. Sometimes that's the same, one or more of the same individuals as the trustee, but frequently the trustee and the beneficiaries are different, right? And so you can think of a trust as a contract. So it's a contract between all of these parties: the trust maker, the trustee, and the beneficiary. And it's a contract on how the estate of the trust maker is going to be dealt with when the trust maker passes away. I also will describe trusts as a bucket. So we talk about, what goes into the trust is the client's estate. So their accounts, their life insurance policies, their home, real property, business interests, perhaps. And then it comes out of the bucket based on the specific instructions that you have left or the trust maker has left in the trust instrument or trust document itself. So I think that's a good way of thinking about it. But it is, just to kind of stress, a contract. And that's why it imposes legal obligations on you if you're a trustee. And if you fail to fulfill those obligations, then you can end up in a world of trouble. So kind of how the typical living trust works. So I've got here, Bill and Mary, they're a married couple. They establish a living trust. So this eases administration during lifetime. So there's no living probate, aka guardianship, and Bill and Mary get to maintain control of their property and their money. So there's no restrictions on how much money they can spend. They can buy property, sell property, change from one bank or brokerage or financial advisor to another. There's no restrictions on them really in any way on how they can control their property and their assets. So after the first death, now this is sometimes different, maybe in like second marriage situations, but just for the sake of this example, let's assume we're not concerned about the surviving spouse remarrying, or there aren't stepkids, blended family type situation. And so we just want everything to stay in the control of the surviving spouse. So, let's say Bill passes away first. I'll pick on the men. We tend to pass away first. Our life expectancy is not as long. So there's no death probate, no probate upon Bill's death. No federal estate taxes up to the exemption amount. We maintain the exemption for each spouse. And then the surviving spouse can be both the trustee and the beneficiary. And so then when Mary, the second spouse or trust maker, dies, there's different ways of doing it, right? I have here a common trust. That's what we'll use when we have minor children who are close together in age. So we have children that are 6, 8, and 11. So we want to have a common trust so that we can do some of these things I've got listed here, provide for common education, protect the inheritance from the children's creditors. So if somebody sues them or they run into financial difficulty or get divorced, protect the children from themselves. I just turned 40, but it seems like not all that long ago that I was an 18-year-old college kid who thought I knew everything in the world, when in reality, I didn't know much at all. If somebody had handed me a bucket of money at 18 years old, it would not have turned out well. Would have been some fun spring break trips. Probably would have had new golf clubs every other month, but I don't think that's what my parents had in mind for their estate. So we can protect children for themselves. And also with trust, we can provide for special needs children. So if a child has a disability, they're receiving government assistance, we can set things up in a way to make sure that they're provided for, that they're cared for, and that they don't lose the government assistance that they're receiving. So factors to consider. Trillions were passed from one generation to the next. People want to exit their business in style. They want to go out on a high note. More retirement plans than ever before, which is a good thing, right? So 401ks are really, have taken off over the last few decades, and that's great. But that means there's more money out there to plan for. Medical costs are increasing. And then baby boomers are retiring. So we've got demographic changes. So both in the workforce and, just generally a whole new generation is going to come into money, and how they deal with it. I'm a millennial. I'm a fringe millennial. Might be a little different than the value system of baby boomers, who might have had slightly different values than the silent generation. And so those are all factors we want to consider in estate planning. So here's some of the discussion points we have. Protect family assets. We want to promote our values. So a lot of clients say, hey, it's important to me. Education is a big thing. Or sports, right? Pursuing sports and athletic competitions. Travel. Definitely a lot. I hear charity. So supporting churches or other causes that have been important to the client during their lifetime. And planning for future generations, and that incapacity planning as well. So kind of got here, blended families, personal things, high intrinsic value, high sentimental value. So there might be some things in an estate that aren't necessarily valued at a high dollar figure. So like one thing that I can think of, I mentioned a moment ago, golf clubs, so I love golf. My grandfather, we're both left-handed, and he grew up playing golf with him. He gave me my first set of golf clubs, which were, I think, Ping I2s from like 1978. Probably not worth a whole lot in today's world dollar-wise, but they mean something to me because it makes me remember my grandfather and those times that we spent together. Promoting family harmony. So this is a really big thing for me. And, candidly, my family was torn apart by estate disputes and litigation. And, to this day, my mom does not speak to her brothers over what happened. And it's terrible to see. And it was all because of estates. And so my motivation is in doing this, in part, is to educate those who are taking over as successor trustees or executors to make sure that they understand what they're getting themselves into and that they're doing it in a way and handling business in a way that is not going to tear the family apart. That everybody at the end of the day can still do Christmas together, still do the 4th of July together. That's what we want. And so most arguments are over personal things. I'm talking to clients a lot about their family history and their dynamics, so, are there things that happen between the kids in childhood that might still be a sore point or a later point of contention? What are the personalities of the children, right? What are their political views, their religious views? It all sounds kind of crazy, but it helps us plan the right way. And the successor trustee, especially if they're not a family member, kind of knowing and understanding that history and those dynamics is very, very helpful. Okay, so moving along here. So creating a legacy, that's what, trusts are really about, estate planning is about. So values, lifetime experiences, health and wellness, impact and contribution. We want to have a legacy of significance. We want to be remembered, and we want, our children and our grandchildren and, really our communities to remember us as people who had an impact, who made a difference and left the world a better place than we found it. I think we all want that deep down in our hearts. And that's what estate planning, can help us achieve, is a legacy of significance. So beneficiary protection planning again, I have a quote here. Do whatever it takes to ensure that when I'm gone, I promote family harmony. The inheritance I leave protects, improves, and enhances the lives of my beneficiaries. And my documents retain my voice, right? So it reflects my values. It reflects my view of the world and how I want my kids to remember me, my grandkids to remember me, and so forth. So we are going to do, my idea with this series is to kind of expand it into a multi-part series about the different facets of trust and trust administration. And so really today, this is just intended to kind of be a general overview of trusts as a whole. And so I say that because disability trustee, I think this is going to be something we're going to focus on more in like a specific webinar. But you can see here, this is who takes over if the trust maker is incapacitated. So, carefully read the trust document, notify the attorney, make sure all the property is secure, because often when we have somebody with a disability, there are people out there who want to exploit financially that person. So notify financial institutions and professional advisors, and then really serve as a caretaker for that person, make sure their bills are paid, everything, stays on track the way that it needs to. Okay, so that's again disability trustees, and a future webinar. We're going to go into that in pretty great depth. Okay, so what to expect when someone dies, right? So I think what actually happens when someone dies and and what maybe we thought was going to happen, those two things don't always, they aren't always the same. And so, when I'm counseling successor trustees, I want them to kind of go into this clear-eyed, right? And so this is going to make me sound cynical, right? But family members want money ASAP. I can't tell you how many times I've come to the office on a Monday morning and have a message, my loved one passed away, or somebody I know passed away. And so we call this person back and when did they pass away? Oh, yesterday. Right. And we want to see if anything has been done with the trust yet. Right. And so, as I allude to in the slide there, these could be family members who are not even necessarily part of the trust or entitled to anything at all. But nonetheless, they show up. So, in those kinds of situations, the successor trustee has got to keep their cool. It can be easy to escalate, right? So, to make, how dare you, mom just passed away, dad just passed away. Why are you worried about money? Those kinds of things, or to really even worse, shut that person out. Don't talk to them at all. Those are things that can escalate the situation. So the successor trustee needs to be clear-eyed about what's going to happen, but keep their cool. And rash actions can lead to unintended consequences. So maybe the trustee is not doing anything illegal necessarily, but just the manner in which they're handling business causes a lawsuit to be filed. And now all of a sudden there's all these legal fees that are being run up, and things are in the court system when that's the last thing that mom or dad would have wanted. So kind of one way I couch things is I tell beneficiaries who are anxious to receive money that really, until there's a death certificate, not much can happen, and that takes a couple weeks typically. And so if that's the case, we can't do anything right away. We can't get started with this. And it's all about the expectations game, right? So we've all heard, under promise and overperform. And so I think that's true with trusts as well, is that we don't want to say, hey, this is going to be done immediately. Trusts are not a magic bullet. So they're not an ATM machine that just dispenses money to the family automatically. And it's important that beneficiaries understand that there are tasks that have to be carried out, things that have to happen before we can dispense the funds. And if we don't set those expectations, that's where people start getting upset that things are taking too long, that, it's not what we thought it was going to be. And so we want to avoid that if we can. So, once we have a person, the trust makers passed away, we want to identify all the relevant parties. So that's creditors. So that's anybody to whom the deceased owed money. So that could be credit cards, medical bills, mortgage, auto loans, personal loans, taxes, medical bills, anybody that they owed money. We need to notify those parties, those creditors, that the trust maker has passed away. Federal government agencies. So the main one there is Social Security, right? So we want to stop Social Security payments. Had it happen before where Social Security Administration keeps sending the Social Security check month after month, and it's kind of a big hassle there to give it back, right? In which you do have to give it back. And so I want to go ahead and notify them. State government agencies here, that would be like if they were receiving any sort of state benefit, or if they were a state employee who gets state retirement. So, a teacher, firefighter, police officer, university professor, anything like that. The credit bureaus. So people don't think about this with trust administration, but we want to notify the credit bureaus. And why would we do that? So fraud is ever prevalent. There are just seemingly endless schemes and new ones that are created every day to figure out how to open up credit cards in someone's name, take out loans in someone's name. And so what we want to do is notify the credit bureaus that the trust maker has passed away, and so that they can freeze their credit and prevent any of that kind of post-death fraud from happening. I mean, there's criminals out there that read the obituaries and just, see who's passed away and then seize on that to do nefarious activities. So, and then finally here, individuals and charities listed in the trust as beneficiaries. So they're also entitled to see a copy of the trust document. So, if I'm counseling a successor trustee, I'm telling them, yep, we're going to go ahead and mail them notice that they're a beneficiary of the trust. We're going to give them a copy of the trust document. But, sometimes trustees are reluctant to do that. I'm sorry, but we've got to do that. That's a critical step. So what is trust administration? So, I got here on the slide, the Oklahoma statutes say little about trust administration, which is definitely true. So we overhauled our trust laws as a state back in 2024, and so that was good. We modernized a lot of outdated laws, but one of the things we didn't get to was trust administration. Now there's a task force that is supposed to give some more clarity or come up with ideas for more clarity, I should say, in our laws on trust administration, but we know how those things go. That could be years before that actually occurs. So for now, if you're trying to look through the Oklahoma statutes about, what do I do if I'm a successor trustee? What's the playbook? You're not going to find much. And so we want to collect, manage, and distribute the deceased person's property, accounts, and other possessions. So that's what trust administration is that process of collecting, managing, and distributing the deceased person's assets. So in administering the trust, the successor trustee has fiduciary duties to the beneficiaries of the trust. And so it's important to uphold that. A fiduciary duty is the highest possible responsibility that one can have under the law. So I'll sum it up by saying that it means that you deal fairly as the successor trustee. You deal fairly with the beneficiaries. That you do not self-deal, right? So you don't do things that benefit you and disadvantage the beneficiaries, and that you are clearly and completely following the terms of the trust document. Now, there's some gray areas, and I'm going to go into this in future webinars about discretionary trust, where the trustee, successor trustee, might have authority to make distributions in their discretion for certain purposes. And so that can be some gray area, but generally we want to follow the trust terms to a T. And so there's some best practices here that I'm going to talk about that facilitate a smooth trust administration. And so my goal in representing a successor trustee is to make sure that the trust is distributed efficiently, legally, and that it maintains that family harmony, that everybody at the end of the day still friends, still love and care for one another, and are not going to battle before a judge. Okay, so 9 steps of trust administration. So I've got those here. So I'll go through them. So locate the estate planning documents, revocable living trust. If the trust has been amended or restated, that means just a entirely new trust document. We want to make sure that we locate all those amendments and restatements. Last will and testament. So one of our goals, our main goals in doing a trust plan is to avoid probate. But it is possible that assets are out there that neither we nor the trust maker knew about. So in Oklahoma, the most common ones I come across are oil and gas and mineral rights. And so, somebody had an interest in a well that was long dormant, and now there's drilling, and the successor trustee is getting, information saying, hey, the deceased had these mineral rights. That's where a will can come in. And if we do have a probate, the original is required. So I say this to successor trustees because I've had a couple occasions over the years where a successor trustee thinking, well, everything's in the trust, or the trust is the beneficiary of all the deceased property and assets, so we're not going to have a probate. We don't need that will. and they dispose of it or destroy it. And then, lo and behold, later there's something else out there, and we're having a problem in probate. And then the personal property memorandum. So if the deceased person left this, it's usually an addendum to the trust, and it's generally handwritten and signed list. And this is specific distributions of items to certain people. So, this person A gets this ring, person B gets this necklace, person C gets that artwork, person D gets that firearms, and so forth. And so, trustees are legally bound, if the deceased has left that personal property memorandum, to follow the list and distribute the items accordingly. So want to make sure we do that, because it goes a long way to preventing disputes. Those are those sentimental things that I mentioned earlier in the presentation. So gather other important info. So life insurance policies. These may list individuals instead of the trust as a beneficiary, but the successor trustee would still want to know about them. And if they do list individuals as beneficiary, make sure that those individuals know that they are beneficiaries under the policy and how to claim the death benefit. Real estate deeds. So if the deceased owned a home or other real property, we want to locate those deeds, particularly if we're going to be selling property. Bank and financial account information. So, account statements, account ownership forms, beneficiary designation forms. We try to make that easy on successor trustees here at our firm by including a section in the estate planning portfolio binder that we provide to the client called Trust Assets. And there we have them include all of the deeds for real estate that's owned by the trust, all the bank accounts and financial accounts, 401ks, IRAs, insurance policies that are owned by the trust or which the trust is a beneficiary. So that way the successor trustee doesn't have to go on a wild goose chase to try to find those things. But sometimes that is the case. So we want to make sure before we take any steps towards distribution that we've located everything. Usernames and passwords. So for those of you who haven't yet done your estate planning, this is something where successor trustees can get tripped up, and that's access to usernames, passwords. So that's email, online banking, utility accounts, social media, and iPhone, right? So, or Android if you're an Android person. So these days, much of our life is on the smartphone. And so if we don't have that passcode, we can't really access a lot of important stuff, even something like pictures to use at a funeral or memorial service. So then tax returns, we want those because that will help the successor trustee know if they need to file a final individual income tax return on behalf of the deceased. And generally, so again, back to that expectations game, they know what type of taxes or the amount, I guess I should say, level of taxes that the deceased might owe. Because, if we tell the beneficiaries, well, hey, the trust is $500,000, but then they find out later that, oh, well, there's $100,000 of taxes. They're going to, wait a second, I thought we were splitting up 500,000, not 400,000. So it can help the trustee, successor trustee, that expectations game. Okay, so then meet with the estate planning attorney. So I have here, I don't need help. How complicated can it be? Well, it can be pretty complicated, right? And so going back to that, I actually promote family harmony and an inheritance that protects and enhances the life, retains the trust maker's voice. Trusts, are and can be, complicated legal documents. Okay. And so just as I'm not highly trained in medicine or, art or some other real estate, some other field, a successor trustee most of the time is not going to be an attorney. And so, they would want to rely on that legal advice. And if it's a well-drafted trust document, it will allow the successor trustee to pay legal fees from the trust. And, it may seem like, wow, we're having to pay an attorney, whatever amount of money to guide us through this. But, trust me, if it ends up in court, maybe you're paying an attorney $3,000-4,000, something like that from the trust to help guide you as the successor trustee through the process. That pales into comparison what happens if you mess up, even unintentionally, and the trust ends up being litigated in court. We could easily be tens, if not hundreds of thousands of dollars in legal fees, which is what happened in my own family. So, I encourage all successor trustees, educate yourself. Stuff like this is part of that, but seek out that legal advice wherever and whenever possible. So that helps play in the administrative strategy and then preparing any necessary documents. So one of the first steps is certification of trust, and affidavit of successor trustee. That's what allows the successor trustee to be able to act on behalf of the trust. And then that tax ID number also. So that is, again, going to allow the successor trustee to access bank accounts, to set up a new trust account if necessary. Make a list of debts and creditors. So debts, I've got here, survived the deceased. This is very important, right? So sometimes family members and beneficiaries might think, well, that was Tim's debt. We don't have to pay that. We're not responsible for that. Well, they are not personally responsible for it, but the trust is. And so we want to identify all of those, and we want to tell the beneficiaries and counsel the beneficiaries, guys, full distributions cannot be made until all the bills have been paid or settled. And that might be a quick thing, might take a little bit longer, but those got to be paid before the trust is distributed and settled. When I identify beneficiaries and heirs at law, so I've got here a beneficiary is an individual or charity designated in the trust document to receive property or money. By contrast, heirs at law are people who would inherit if the deceased had no estate plan at all, so no will or no trust. A lot of times those are one and the same. So beneficiaries are also heirs at law, but they can be different. So it's important we distinguish. Heirs at law might be entitled to something from the trust, but they aren't necessarily. So let's say that I'm an heir at law of my parents, and they say, well, sorry, Tyler, we are not leaving you anything in the trust. It's all going to your brother, Brian. Well, I'm still an heir at law, but I'm not a beneficiary, so I'm not part of the trust administration. So we want to distinguish between those two, locate people, figure out where they are, their addresses. Inventorying and securing the trust property. So we want to determine the value of each asset. It could involve hiring professional appraisers. So those values that you see on Zillow or the county assessors, those are not always accurate. So we want to enlist professional appraisers as necessary. The other thing is securing trust property, namely the house. So had so many houses or seen or heard about this so many times where deceased person's house gets robbed even during the funeral. So if you're the successor trustee, change those locks, make sure the property is secured. If it's in a rural area, the county sheriff will be glad to kind of patrol the area and make sure that nothing is awry. File tax returns and pay taxes due. As a successor trustee, you have a responsibility to make sure that the deceased final income tax return is filed. There might be a trust tax return. So we're going to go into in future webinars the specifics of taxes as it relates to estates and trusts. So this is just an overview. A state tax return, not a thing for most people, as we talked about. But the critical point is if you as the successor trustee settle and close the trust before all returns and taxes have been filed and paid, then you can be personally liable for the amounts owed. So say, $25,000 of taxes are owed, and you kind of blow off filing the returns, or, you say, well, the family members really, really want their money now. I'll just go ahead and give it to them. And then bam, they come back with that tax bill. You as the successor trustee are personally on the hook for it. So we cannot close and settle and fully distribute the trust until all taxes have been paid. Maintain an accounting. So this is something that you've got to do as the successor trustee, which is to keep track of deposits, expenses, and distributions. and give copies of that accounting to the beneficiaries. So they're entitled to that. Most trust documents say at least annually. The vast majority of trusts that I administer were done within a year, so there may only be one accounting. But I think transparency is a critical thing here. That's something to really be attuned to, is transparency. If a beneficiary asks for a copy of the statements, give it to them. If they want an accounting, provide that accounting. So I've had so many trustees where they're not doing anything wrong. They're not embezzling money. They're not expending any trust funds on inappropriate or illegal things. They're following the terms of the document, but they're just not transparent, right? So they say, well, the trust says I only have to give you one accounting at the end of all this. So, go pound sand. You're not getting the statements. You're not getting the accounting. We as human beings naturally assume that if somebody is not communicating with us or not giving us information, well, they must be hiding something. So, if you're a successor trustee, don't put yourself in that situation. And then, lastly, on the accounting front, run all expenses and payments through a single account, if at all possible. So that makes preparing the accounting much easier. If I am working with a successor trustee, or I'm asking the successor trustee to provide me with a list of expenses, payments, distributions, and they're having to go through, or I'm having to go through 10 different accounts to try to piece together all of this and make sure I have a full and accurate accounting, that takes a lot of time. So that delays the distribution of the trust. And it also increases the legal fees, the CPA's fees. So, if we can establish kind of a so-called operating account for the trust, that is really ideal, and run everything through that. Okay, so then kind of the last thing in closing here is just really an overview of successor trustee responsibilities. So to secure and safeguard all possessions owned by the deceased until they can be distributed, communicate the status of the administration and provide pertinent information. Again, I cannot harp on that enough. That's the ticket to really preventing or heading off problems before they become a big issue. And so make sure all outstanding financial and legal obligations of the deceased are resolved, and then distribute the deceased possessions according to the instructions left in the trust document. So something else I tell successor trustees is that, you may not necessarily agree with what the deceased or what the trust maker is doing in this document. You may think that they should have restricted how your brother Johnny spent the money, or they maybe should have waited until that grandchild was 30 instead of 21 before they received funds, or we should have supported this charity instead of that one. It's successor trustee. It's not your money, right? It's the deceased money. It's the deceased vision, their goals, the trust maker's legacy that you're trying to carry out. And so you have to have that frame of mind, is I'm not doing this for me. I'm truly a servant, and I am the stand-in for my loved one who is not here to be able to do this themselves. And I think, that coupled with the transparency and setting the expectations game, if you do those three things as a successor trustee, I'm really confident that at the end of the day, things will proceed how they need to. So I know I kind of went a little bit over the allotted time. Us lawyers have never been known to be short-winded. We're quite the opposite. We're very verbose, but so I appreciate everybody hanging in there. If there are any questions, I'll stay on for another minute or two. You can put those in the chat box, and happy to answer any questions that anyone has. Okay, well, always feel free to reach out if you're a successor trustee. You can visit our website, barrettestatesolutions.com. We have a lot of materials there. You can also check me out. I'm the legacy lawyer on TikTok and YouTube, if that's your thing. I'm just now kind of getting into the video world. my wife's kind of working on me with that. We'll see how that goes. But we've got a lot of educational content up there as well that you can check out totally for free. And of course, if you have been named as a successor trustee, then and you feel like you need legal representation, you're of course free to contact the office. Bonnie there in the chat asked when the next webinar is. So, okay, I've got a couple questions here. So the next webinar we have not scheduled yet, but I expect this to be an every other month thing. And we're also going to have a separate series on asset protection. So I would guess that our next successor trustee training webinar will be probably in August or September. And then is the successor trustee compensated? So that's another question here in the chat box. So the answer is it depends on the trust document. So the trust document's always our lodestar. That's what we go back to. And, if you read Oklahoma statutes, the Oklahoma Trust Act, it says unless the trust document states otherwise. So we want to look to that trust document. And that's going to vary case to case. Sometimes the trust document says the trustee can receive reasonable compensation, which might be like a reasonable hourly rate. Maybe it's a flat fee, they get $10,000. Maybe it's a certain percentage of the trust itself. So we'd really want to turn to the trust document. One other point I make on that is you might guess that beneficiaries will voice objections to trustee fees. So because if they haven't watched a webinar like this or been a trustee themselves, they don't understand all the work that the successor trustee has to do. So they might not feel like the fee is justified. So sometimes if there's a dispute over that, we might want to be really meticulous with our record keeping and what we're doing, as successor trustee to make sure that that we can kind of justify the fee that's being charged. So if there's any other questions, I will take those real quick. But otherwise, I will let everyone get on with their evening. I want to thank everybody for taking time out of your busy schedule to be with me here today. I hope this is helpful. Also feel free to let me know if there's any specific ideas you have for future webinars or certain aspects of successor trustee training that we should go into more depth on. So thank you again, and I look forward to seeing everybody on the next webinar. Appreciate it. Have a good evening.